I should apologise to those of you who are not FSA regulated. I can only say that I will be brief, and you'll be pleased to hear, and I'm sure by the end of my presentation you'll be pleased that you're not within a regulated business. Some time ago, several years ago, after the crisis and the identification of issues around the regulatory failings that were perceived to have existed at the FSA, the FSA changed its approach to its role and the way in which it regulates. And you have here a quote from the FSA, then Chief Executive, about probably looking quite enviously at the SFO, saying that it was perceived that the FSA was somebody that the industry wasn't scared of, wasn't afraid of, and since then they've essentially set out to change that. And my presentation could probably be neatly summed up by this helpful cartoon, which I've had on my wall, my office wall, for some years now. It's considerably out of date in terms of when it was published, but it's still very, very relevant in terms of what we experience and what firms are experiencing on a day-to-day basis. You'll be aware that we've got a new regulatory architecture coming into place. The government have decided that they'll sweep away the problems of the past by some new acronyms, and I think that the reality is that they are largely just about new names, new labels for what is effectively the same body of people performing the same function, albeit with slightly different powers. The FCA document, there's an hour-long presentation tomorrow morning if you want to come back for more bacon sandwiches on the FCA. But they published a consultation document, which is, well, not really a consultation document, which is long on rhetorical statements about their aggressive status and stature, but not a great deal of detail. I think what is interesting is the way in which firms are now being treated by the FSA and the way in which the FSA approaches its role, particularly in relation to supervision. I don't have the time to go through all the new powers. Essentially where they are now is about being intensive, intrusive, interventionist in everything that they do. They've moved away from being reactive, so that where firms mess up and there is a mis-selling scandal, they get involved and try and clear up the mess. They now want to try to prevent the scandal from occurring. Ambitious, I may say, because it requires a significant amount of educated assessment of the situation, which many think is probably beyond the FSA, but we shall see. They are moving to what they refer to as judgment-based regulation. You will have heard in the press a great deal about the focus on culture. We've had a number of high-profile cases recently which have identified that some individuals within the financial services sector don't operate with the levels of integrity that the FSA would expect. And in order to try to rectify that, the FSA have set about something called credible deterrence, which is essentially all about more fines, higher fines, and more actions against senior management. A couple of quotes here emphasising the difference of approach in relation to the role of enforcement at the FSA. You'll see for yourself that you know, Sir Callum McCarthy was quick to emphasise that the FSA was not enforcement-led. Lord Turner has since decided that that needed to change, or has changed. In the words of a senior FSA representative, when asked whether or not the FSA was now enforcement-led, he said, no, of course we're not enforcement-led, we're just no longer not enforcement-led, which is helpful. One of the things that is a focus for the FSA now, and it's an incredibly difficult thing for firms to respond to, is the focus on senior management responsibility, attacking individuals. This is a statement from the FSA annual report which says that we consider that actions against individuals has a greater deterrent effect. Well, who would have thought? If you are facing individual disciplinary sanctions where you are going to be required to pay a financial penalty or to lose your career, then you are going to think more carefully than you might do if you were just calling on your PI insurers to pay for the costs of a mistake. The John Pottage decision, I could do a whole seminar on this alone. It's a fantastic case demonstrating the need sometimes to push back against the FSA. John Pottage was the chief executive of UBS's wealth management business, faced accusations that he'd failed to perform his role properly and was facing a £100,000 fine. He took that case to the tribunal, fought the FSA all the way, and thankfully he won. But in doing so, he did. The court, the tribunal, did decide some very important points which are worth noting for senior management, and that's that essentially we've moved from a situation where you could be disciplined for misconduct to a situation where you now have to proactively identify issues. You have to be very, very good at your job in order to avoid the potential for disciplinary sanction, which is quite a threat for individuals, I think. Particularly if you're a chief executive, where your concerns will be about profit, not necessarily about compliance. We've seen in the introduction of Damoclean letters, there was whereby one person has to be nominated as responsible for a particular issue, and of course if that issue goes wrong, that person then is hung out to dry by the FSA. And we saw it this week with the consultation paper, where the consultation paper comes with some attestation wording at the back, which a chief executive has to sign to say that he has read that document, that he's undertaken a review of his business, and none of the problems identified by the FSA exist within that business, or that they've been fixed. Of course, that attestation is written in blood, and if there is a problem subsequently, the FSA will come back for that individual. So again, it's quite a difficult situation for individuals at the top of those organisations. You'll all have seen the FSA has been quite aggressive in relation to market abuse and insider dealing. 14 convictions for insider dealing since 2009, more on the way, some involving financial institutions. And one other point that's worth making around in terms of the regulatory environment, the FSA has relinquished its policy-making role to Europe. We now have a number of European supervisory authorities who have taken up the policy-making role, and the UK no longer has a role to, it has a role to play, but only in the sense that it tries to influence, as one of the member states, what comes out of Europe, which is, for those of you involved in the industry will know, what comes out of Europe is not always necessarily great for the UK industry, and I think it's a real concern for lots of the people we speak to about how the regulatory environment will develop. I've asked the question, should you be afraid of the FSA? It's obviously a very, very quick run through, and I think the reality is that the FSA is much more aggressive, it is much more intrusive, it's much more difficult to live with the FSA, but at the same time most firms are well run and have nothing to be afraid of. And what they do need to do is to be aware of where we are in terms of the regulatory environment, to be proactive in identifying issues and tracking issues, and be prepared. This is the nothing to fear but fear itself quote is obviously from FDR in the context of the Great Depression, so possibly quite apposite for a number of reasons. But one of the things that we have seen, and which does worry me, is that the fear which firms have of the FSA forces them into positions where they are prepared to make concessions which they're not really obliged to make. You see firms making settling cases for fear of upsetting or further aggravating the regulator in circumstances where they're sacrificing their legal rights, potentially sacrificing their defence of civil claims. I think it's a real problem. It's easy for me to say and very difficult for firms to do, but I think there will come a point where firms and the industry has to push back against the FSA and not be afraid. So that's a very quick run through. I hope that was interesting for you.